Greetings. Steve Pippinger here from Pippinger Partners again with some useful information on being a tenant in New York State. How are you doing? I hope you're well, staying in and social distancing as much as you can. You know, I'm continuing to put out information for tenants in New York so that you know your rights and you do not let an unscrupulous landlord take advantage of you, particularly in these times. Right now, people are anxious with what's going on and need to know now more than ever what their rights are as tenants. Times like these, with uncertainties about meeting rent, etc., knowing your rights as a tenant is even more important. I'm going to speak about something aptly called the New York State Roommate Law. It is Section 235F of the New York State Real Property Law. I'll put a link below to the actual law in the video description so you can check it out yourself. And it's typical lawyer speak or law speak, so it's a little bit hard to understand, but this is the gist of it. So what exactly is this law and why does it exist? As a resident of New York, you know how much rent can be, especially for tenants living within New York City. Often, rather than a single person living in a studio or one bedroom, friends will team up to live in an apartment to have a roomier place to live, but with less rent per person. Well, New York law acknowledges this fact and gives tenants and their roommates certain rights. Let me start by saying that the law entitles you to have as many roommates in your apartment as there are people on the lease. One of the caveats is that the roommate cannot actually be on the lease, which is a tenant, or on a sublease, which would be a subtenant. This limit applies to unrelated roommates. In other words, the limitation wouldn't apply to kids, parents, etc. And here's a for instance. If there are two people on a lease, those people are allowed to have two additional people as roommates. The landlord cannot prohibit this. Even if the landlord were to put a provision in the lease that you're not allowed roommates, that provision is unenforceable. Your only requirement really is that you notify the landlord within 30 days after the person or persons move in. But in all honesty, if you don't notify the landlord, there's no penalty or no punishment in the law for not doing so. So it frankly doesn't really matter as a practical matter. The roommate law is important information to know. Landlords will commonly try and violate this by telling you that you cannot have a roommate and that the person or persons must sign the lease. This is false. So let's just recap. A tenant may have the number of unrelated people as roommates equal to the number of tenants on the lease. For instance, if there are two people on the lease, they're allowed two unrelated roommates. More than just may have, remember, you have the right to have these roommates. It's enshrined in the law. Any provision, as we said, in a lease that says you can't have those roommates is void and unenforceable. You must inform your landlord within 30 days, but there's no penalty if you don't. If you exercise your right, this is very important, and the landlord threatens to take any retaliation against you, like threaten to evict you, threaten to raise your rent an exorbitant amount, that is illegal retaliation. And they're not allowed to do it. Remember, though, a roommate is a person not on a lease or a sublease. The bottom line is this: know your rights. Exercise your rights. Don't be afraid. Tune in later, and I will be offering some more information about being a tenant in New York. Most importantly, remember to stay safe. Have a great evening and take care.